Welcome to Partnered Up Business Law, Deals, and Dynamics.
Welcome back to Partnered Up Business Law, Deals, and Dynamics with Jeff Fink, partner at Coren Lichtenstein LLP in Massachusetts. Jeff advises business owners and partners on formation, growth, and dispute resolution for closely held companies. I'm Evan Mack, and today we're continuing our discussion of indemnification, this time focusing on indemnification and contracts between private parties. Jeff, sir, welcome back.
Evan, thanks for having me.
It's a pleasure. Jeff, so to recap on part one, can you go over what kind of contracts other than LLC and partnership agreements typically include indemnification provisions?
Sure. A lot of contracts have this kind of language in it. Any kind of M&A agreement would have it. Agreements by investors going into a company, consulting agreements, service agreements, particularly investment banking service agreements, bank loan agreements will have them, sometimes particularly governing any collateral they might hold. License agreements, anything else involving intellectual property. And if there are environmental issues, indemnification can pop up anywhere because nobody wants those. They're all a little different.
Yeah.
They do follow similar patterns, though. They're the cousins to the indemnification agreements that protect directors, officers, members, managers, and partners, but they're not quite the same. If you're interested in those kinds of indemnification provisions, if they're important to you for whatever situation you're in, please listen to part one of this episode. One really important difference is that unlike these director and officer type indemnification provisions, there's no statute that automatically backstops the language of the contract. Actually, I say that as an absolute statement, but nothing in the law is absolute. I'll talk about a couple of possible exceptions in a few minutes.
In contracts between private parties, the procedures really matter. Why is simply saying I agree to indemnify you not enough? And why does it make sense to start with the scope of indemnification?
Great question. You have to define what claims are covered. It's like an insurance policy. Regardless of whether you're the person giving or receiving indemnification. I'll give you some examples. So if you're doing a contract with an investment banker, they will insist on being indemnified for almost anything and everything that arises out of their engagement. If you're doing a stock purchase agreement for an M&A transaction, for the most part, indemnification is going to cover just breaches of the specified representations and warranties in the agreement and some specific claims like pending litigation. In that context, something to note if you're a drafter is that strictly speaking, indemnification only covers third-party claims. It doesn't cover claims between the parties. Contract drafters sometimes act as if it does, and so if that's what you mean, you need to say it. Okay, and in something like a license agreement, indemnification is mostly going to cover claims of infringement. In supply agreement, it's mostly going to address product liability kind of things. So really, all depends on the context.
When drafting indemnification provisions in contracts, how do parties usually address who is providing the indemnification and who the indemnified parties are, including the use of representative, concepts?
So it really goes back to what the purpose of the contract is. If it's something where one party is conveying some assets or rights to the other, the one who's on the receiving end wants to make sure there's no baggage that goes along with it. And that's where indemnification comes in. The people getting indemnified are usually the receiving parties and then a laundry list of their affiliates like directors, officers, members, managers, employees, contractors, and so on. The people doing the indemnification or the parties doing the indemnification are usually the transferring parties, but not always. For example, in an M&A agreement, we sometimes see a specific provision where the buyer, the receiver, the receiving party, indemnifies the seller. There's a tax claim made against both of them where the taxes really only apply to the period where the buyer owned the company, only apply to that partial year. So as you're drafting these, they can get really specific.
What formal requirements typically apply in contractual indemnification, particularly around notice, Jeff?
Um, so notice is one of those things that gets litigated. So it's like with an insurance policy. If you want somebody else to pay your bills for a claim, you have to submit a notice of the claim. Some of them put a set number of days on it. Others say as soon as possible. Others say reasonable time period. Some of the law there talks about whether um, whether the party getting the notice is materially prejudiced by not getting the notice. I'll give you an example of that one. If you get served with a complaint and you have 20 days to respond to it, and you wait 15 days before telling the party who's supposed to indemnify you about it, they're not going to like that because that really impedes their ability to defend the claim.
Hmm. So how is assumption of the defense usually handled in contracts, and what expectations tend to apply?
So if you're paying the bills under an indemnification agreement under one of these contracts, you want to control the defense of the claim because you want to make sure it's done right. Usually the indemnifying party has a certain period of time after notice to hire a competent lawyer, meaning not necessarily your brother-in-law. And if they don't, the indemnified party can step in and pick the lawyer, but I've actually never seen that happen. There's usually an exception in these agreements if there's a conflict of interest, because both parties, the indemnifying party and the indemnified party, get named in the lawsuit, and they have different interests, different or additional defenses is usually the way it's phrased. Depending on the standards that are used, the indemnified party may be able to pick their own lawyer in that circumstance. But keep in mind that those kinds of provisions get really technical, and they're often negotiated.
Hmm. So how do contractual indemnification provisions typically deal with limitations on settlement?
It's really a question of who needs to agree to a settlement, because most claims are settled. So I usually try to put a few limitations on what a settlement can contain without the consent of both parties. And sometimes I'll do this regardless of which side I'm representing, because I think it's helps everyone to be clear. First, the settlement that can be done unilaterally has to involve the payment of money only, which the indemnifying party pays. Has to give a full release of the indemnified party so they can't get sued again. Can't involve an admission of liability because that kind of stuff can be used in another case. And sometimes there's specific language about criminal matters. But you want, if the settlement's kind of complicated, you want both parties to sign off on it.
Hmm. So Jeff, what role does contribution play in contractual indemnification provisions?
So contribution is one of those legalese terms. I had mentioned that there are exceptions to the idea that there's no law backstopping contractual indemnification provisions. One of them is called contribution. Sometimes it's made explicit. For instance, you usually can't indemnify somebody for violation of securities laws. It's viewed as against public policy. It's things like you misled your investors, disclosure requirements weren't met, investment fraud, that sort of thing. So contracts that have to do with securities matters usually have a provision in them that say that if indemnification is not available, because you'll try it in the first instance, but if indemnification is not available, each party will contribute to the overall cost in a manner that reflects the relative cost and relative benefits of the parties. And that then becomes a negotiation itself at the end of the day. But there's coverage there if you're the person who wants to get indemnified. There's a related concept you might have heard of called subrogation, also another legalese term. Great example, if there are two guarantors of a bank loan and one of them pays up, the one that has paid usually has a claim against the other, except the banks these days will sometimes want you to waive it. How much the claim is for depends on the circumstances, but keep it in mind. Basically, the idea is if you're paying something that really is a liability of somebody else, you may be able to go back after them.
So more broadly, Jeff, where do contractual indemnification provisions most often go wrong in practice?
I think it's safe to say that anywhere they can go wrong, they will. And I know that's kind of a dark way of looking at the world, but these provisions get looked at in the context of an active litigation most of the time, or an active governmental investigation, or some other kind of claim. And because of that, you have people who are looking for loopholes. They can get really complicated. We haven't talked about caps on the dollar amount of indemnifications, collars, minimum, maximum, deductibles, exclusions, and provisions like that. They're all things that are always negotiated. But as with any legal document or any human arrangement, the more complicated you get, the more likely it is that somebody will get creative trying to find a problem if that's in their interest. So there are often disagreements on scope, just like with insurance policy, what's covered. We talked about the procedural stuff. Is the notice okay? Who's picking counsel? Are they defending the claim aggressively enough? And finally, there are usually some exceptions to the scope in the contract that are kind of loose language. If the indemnified party engages in gross negligence or intentional misconduct, they don't get indemnified. But what that means is really fact specific. And if the contract has that language in it, it does come up all the time.
So, Jeff, before we close things out, any parting words for the wonderful people that tune into this podcast?
Yeah, the feedback that we've been getting is that people like some of the stories that I tell about how things work and how they don't work. Some people like the fact that unlike some legal podcasts, it does grapple directly with these meaty issues. So if you want to hear more of anything or less of anything, please reach out and let me know.
Awesome stuff, Jeff. Appreciate the time as always, sir.
Thank you.
All right, guys. That concludes today's episode of Partnered Up, Business Law, Deals, and Dynamics. To learn more about Jeff Fink and his work at Coren Lichtenstein LLP, visit cl-law. Be sure to like, leave a review, and share this episode with someone who might need it as well. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.